Welcome to the Napa Legal Podcast. I'm Frank DeVito, Senior Counsel and Director of Content at Napa Legal.
And I'm Mary Margaret Bush, Executive Director.
You're listening to the Napa Legal Weekly Podcast, where we explore religious liberty through the lens of faith-based nonprofits. This week, we'll be covering several interesting topics. We're going to talk about President Trump's pardon of 23 FACE Act convictions. We're going to talk about Becket Fund's new Religious Freedom Index and a related case called Mahmoud versus Taylor. And we're also going to talk about a recent article by Ian Spear about data privacy and AI and how the use of these technologies by nonprofits and the increasing state regulatory regime governing them may create interesting situations in the years to come for faith-based nonprofits. So with that, let's get into the first topic. For those listening, by the time you're hearing this, it will have been 2 weeks since the new administration was inaugurated and came into Washington, D.C. And there has been such a flurry of action, of executive orders, of things, a lot of which intersect with the things that we do here at Napa Legal and with religious liberty issues. I'm thinking we're probably going to have a special episode in the coming days just to cover a lot of these presidential executive orders and other actions. But for today, we're going to focus on one in particular that I think will be of interest to our listeners. So if I think most of our listeners are probably familiar with the FACE Act, especially because it's generated a lot of national news in recent months and then again in recent days due to these pardons. So for those who don't know, this is a federal statute that criminalizes damage, obstruction, preventing access to, threatening, or intimidating those who enter certain facilities. And for our purposes, it's mostly abortion clinics that have been the targets of these prosecutions. So what this means in practice is that if somebody is damaging or obstructing access to or threatening people or prohibiting people from entering an abortion clinic in this case, then they're subject to these FACE Act prosecutions. And what's made this such a hot button issue is that over the last few years, so under the Biden administration, the Department of Justice has prosecuted a couple dozen peaceful pro-life advocates who were protesting, praying at the or near the entrance to abortion clinics or other facilities that offer abortions. So the first thing that has made this such a politicized issue is that if you read the FACE Act and if you just look at the words, right, damage, obstruct access, threat, and intimidate, this is not supposed to be a vehicle for prosecution of people who are praying or protesting. And I think you don't have to think too hard or make too much of a jump to realize that these are actually First Amendment protected actions to protest or to pray in public. So what this statute is supposed to do is prevent actual threatening behavior or physical prevention of people from entering an abortion clinic. But that's not how these prosecutions have gone down. Again, these have been peaceful protesters. And it's created a lot of stir in recent months, and then especially as President Trump took office. And so there was, I know, a lot of work going on in the background in recent weeks. The Thomas More Law Center, Thomas More Society, the good attorneys there have been working on this for weeks. They wrote a memo that was given to the incoming administration, I believe last month, talking about the individuals who had been prosecuted, many of whom were in jail for peacefully protesting against abortion. They had been prosecuted and jailed under the FACE Act. And so the groundwork had been laid for this for weeks, and a lot of people in the pro-life movement had been paying close attention to this case. And so the president did announce on Thursday, the 23rd, I believe, of January, and signed the pardons and pardoned, it was 23 pro-life advocates who had been imprisoned under the FACE Act. So this was done on the eve of the National March for Life, and it marks a big change from the last administration when the DOJ was prosecuting pro-lifers under the FACE Act. Before we get to Mary Margaret, I'd love to hear your comments, but just a couple of related things going on right now related to the FACE Act. Two things. For one, recently there's been a directive released by the Department of Justice in recent days limiting enforcement of the FACE Act. So what this says is that the FACE Act is now only going to be enforced by the DOJ in cases that involve serious injury, damage, or death, which I think is not just a policy call, but a faithful interpretation of what the statute says, right? Because anytime that somebody is doing the things that I listed in the statute, right, damaging, obstructing access, threatening, or intimidating people entering, that's going to result in damage, injury, death, right? So I think this is mostly a reinterpretation to say we're no longer going to stretch the FACE Act beyond what it was passed to do, what the plain meaning of the words is. Um, but then there one other update. So Senator Mike Lee from Utah also just recently, I believe he introduced or announced that he's going to introduce a bill to repeal the FACE Act altogether. He's stated pretty explicitly that this has been unjustly used to target pro-lifers. I believe there's an article covering this that said something like 97% of FACE Act prosecutions that are brought, like 97% of them are prosecuting pro-lifers, even though the FACE Act could technically be applied to people who are obstructing access to like a pro-life pregnancy center. So the mood seems to be that this is being used rather specifically to target pro-life protesters, that it's not being used even-handedly. And one other thing I'll say before I pass it off to you, Mary Margaret, is that I think the repeal of the FACE Act to me makes sense because the reality is if you take the Department of Justice directive and say we're only going to go after these things if there's serious injury, damage, or death, or if you go back to the FACE Act words themselves and say, we're only going to prosecute if somebody's obstructing entrance, if somebody's damaging a clinic, if somebody's threatening people. There are already criminal laws on the books to deal with all of these things, right? Every state in the union has trespass laws, has assault laws, battery laws. There, this seems like a vehicle to take um, what are often rather minor acts of obstruction or sometimes even peaceful protests and turn them into federal crimes, right? So to me, I'm completely on board. I think a complete repeal, not just a limited enforcement, makes sense because I think at this point it's been shown that this bill has been pretty unfairly targeting pro-lifers, and frankly, we already have laws on the books that can deal with any of these situations that get out of hand.
Yes, I couldn't agree more, and this issue took on a new kind of a new level for me last week because right before the March for Life, there was a Law and Liberty Summit that was held to connect pro-life lawyers with ministries. Well, the Thomas More Society was there, Andy Bath, Tom Brecka, their team was up front doing a panel with Paul Vaughn, and he's describing this weekday morning. He asked his kids to get in the car so he could take them to school, and then suddenly his house is surrounded, the FBI is there with weapons drawn. Um, it is just incredible that this happened in the United States of America to a law-abiding, husband and father. He recalled trying to debate what to do and then realized all he wanted to do was protect his family's safety, and he thought, "Well, I have to just turn myself over so that the threat to my family goes away," which I'm not even sure legally is actually the best course of action, you know? Um but he turned himself in, and, during the panel, someone interrupted the testimony and said, "This is just breaking. President Trump has pardoned you." I mean, the goosebumps, the tears, the emotion, I had not been aware that was, scheduled or was in the works for that day, so I was completely blindsided and just realized these FACE Act pardons weren't just any day one executive order. This was someone's life that was hanging in the balance and is now restored to a just outcome. I mean, I couldn't agree more with you, Frank. There are laws on the books to prohibit to punish criminals. This was not one of those.
Yeah, as much like I said, there's so much exciting news coming out of the new administration and all of the federal actions that have been going on, but we'll deal with those more, I think, in the next episode. At this point, I'd love to turn to the I think it's the sixth edition of the Religious Freedom Index that the Becket Fund just released. Mary Margaret, I know you've been diving into this. I know you have a lot of thoughts. I'd love to hear your thoughts on the index.
Yes, so we obviously do talk a lot about religious freedom. It's one of our animating values at Napa Legal. Um, it's an unalienable right, which means that it cannot injustice be taken away, even with consent. At the same time, while religious freedom is not something that's subject to popular vote, at the same time, public opinion is very, very important. It's a way of telling about the health of our nation, our trajectory. And it also communicates to policy and lawmakers that this is an issue that needs to continue to be defended and prioritized. So Becket took the initiative, as Frank said, several years ago to develop the Religious Freedom Index, excuse me, which pulls public opinion on a number of key issues related to religious freedom. So there's a core group of, I believe, 20 questions that have been asked year after year. And then there are also some kind of a little more short term or current event specific 15 questions that will be swapped out depending on what kind of the demands of the moment are. So the results of this year were very encouraging. That the survey confirms that not only is this an area of common ground, but that support for religious freedom publicly is actually at an all-time high, with over 80% of adults supporting religious freedom. 78% of adults believe that religious freedom needs to be protected in private businesses, which is a very important theme right now. Um, and then another part of this study looked at Gen Z specifically, which historically has not been the demographic that most supports religious freedom, but that generation has increased in their support of religious freedom 5% in just the last 2 years. So there's a trend developing there that's very, very important. One of the aspects of the survey that I think Frank and I would be are most interested in was a question about which branch of government best protects religious liberty. So the answer was the courts by was it 31% of the votes, with the second highest going not to the executive or legislative branch, but to state governments. So there's a really important message here that state governments need to continue to be proactive, be protagonists on the religious freedom issues. And I was encouraged to see that the public recognizes that and that people are aware that they can turn to their states as well as to the federal government for protection of their First Amendment rights.
Yeah, I love this index. And one thing I want to say, so as most of our listeners know, Napa Legal has an annual Faith and Freedom Index where we rank a number of state laws that affect religious liberty, particularly concerning the liberty of religious organizations, of faith-based nonprofits. But this is a great opportunity because this is part of our mission as an organization. I think in general within the religious liberty movement, this needs to be stressed that we are collaborative and we are not in competition with the other organizations who are doing this important work, right? So whether you have the what Becket is doing with the Religious Freedom Index is amazing, especially the focus on polling and really getting a sense on the ground of where people are on religious liberty questions is great. The Center for Religion, Culture, and Democracy out of First Liberty Institute, they also have a Religious Liberty in the States Index, which sounds a lot like what we do at with the Faith and Freedom Index, but they're mostly rating different laws. And my point is that this is all really good work. We'd actually love to and intend to collaborate more with these other organizations and really promote their work, like we're doing here with these other indices, because really the more we can get information on religious liberty, how it's being handled at the states, how it's being handled by the federal government, how it's being handled, or how it's being perceived in the minds of the voters, of the people. This is all good. So the more religious freedom indices, the better. We're just excited to see that there are these other companion studies doing similar work and really adding to the conversation on this. So, Mary Margaret, did you want to say anything more on the index, or should we flip to the next couple of issues?
Just to confirm what you said, I'm really excited to put together these indices, and as you said, we would love to do some kind of panel where it's everyone kind of presenting their research so that we can put together like a holistic picture of the current state of religious freedom in the country.
Um, Hopefully, more to be announced on that. I know there have been some quiet talks about hopefully doing some collaborative events. So, would love to make that a reality in 2025. Now, I know related to Beckett's Religious Freedom Index, one of the issues that they polled on in this year's index was the ability of parents to opt out from certain controversial topics in the classroom. And there was an overwhelming response that people are in favor of these parental rights. This touches on a case that Becket is actually involved with, Mahmoud versus Taylor, that the Supreme Court just recently agreed to hear. We touched that last week. We'll get back to that in a minute. But first, I just wanted to give honorable mention to a really interesting piece that is especially useful to nonprofit listeners, people who are interested in nonprofit law and the work of faith-based organizations. This was an article written by Ian Spear, who's a friend of Napa Legal. It was just published in Public Discourse a couple of weeks ago, and it's a fascinating dive. I'm not going to go too into detail because the topic he touches on is data privacy and artificial intelligence and how religious organizations use these technologies and how state regulations are going to start to get thicker and harder to navigate in the coming years, especially on AI. And first of all, I just recommend that everybody listening to this read this. So it's by Ian Spear. It was published in Public Discourse, and really everybody should take a few minutes to read this article. It's called "Emerging Tech and Religious Freedom." It was published on January 21st. So just very quick, high level, what you should expect here. He starts the article and he's talking about data privacy. Now, anybody involved in the work of nonprofits has probably touched this. Data privacy is an area thick with regulations. A lot of organizations have started to get savvy on this issue to develop a data privacy policy for the organization, because you do have some issues that are going to conflict with data privacy laws and regulations, right? If you have donors who contribute online, even if you just have a mailing list or cookies and you're collecting, personal information about your users, your readers, your donors, you probably have data privacy that's going to fall under digital data privacy laws in the state where you're functioning, or in multiple jurisdictions, perhaps. So over the years, nonprofits have started to get smart on this. And what Ian does in this article, which is really insightful, is talk about how AI is the next frontier, where nonprofits are using it maybe more than they realize, and the regulatory landscape is going to get more real in the coming years on AI. Right? AI is in the news. If you're paying attention to political news, cultural news, more and more people are talking about AI. Has it run amok? Do we need policies? Do we need better oversight, regulation? So regulation and more talk on this is coming. And in the meantime, Ian points out we use AI all the time, even if we think of ourselves as more Luddite, technologically adverse, kind of old school faith-based organizations. We do use it, right? People use AI tools to analyze the behavior of users and customers, to track click rates, open rates of emails. You even see organizations creating like evangelist chatbots, right, that are answering your questions about faith and morals. So AI use in religious organizations is real. And again, I'm no expert, but just look for this issue as it starts to get thicker and more prominent, because there will be regulations around the use of AI. And I really encourage you, as a starting point, whether you're really interested in this topic, Ian's an expert. If you've never touched this topic, but you're interested in religious liberty and nonprofit law, this is a really good primer to just start to think of some of the big picture questions, Christian perspective, which Ian just does so well in this article. So again, I'd highly recommend you read the article. And with that, we'll move on to our last topic, which is this case that's going to go up before the U.S. Supreme Court, Mahmoud versus Taylor. And I apologize, I'm probably saying that name wrong.
Yes, yes, and Frank, I'm with you. I think it's Mahmoud, but I'm pretty sure I'm butchering it. So Mahmoud versus Taylor. I am pretty sure this is the most outlandish case I have encountered in my professional career. The deeper I dove into the details, the more surreal the whole thing is. And as Frank said, a great place to start is just to bridge from the Becket Religious Freedom Index conversation we were having earlier. So that same survey pulled their audience on support for religious exemptions, protections for parental rights in the context of sex education in public school. So this is a sensitive topic with deeply religious implications. 77% of people believe that parents should be able to protect their children from being kind of misled in these areas, or led in a way that's not consistent with their faith and their culture and their tradition. So you would think this would not be a controversial area, but we are about to go on a wild ride. So starting in, I believe it was May 2023, parents in Montgomery County, Maryland, a group, it's diverse from a faith perspective. This is a group of Muslim parents, Eastern Orthodox parents, Roman Catholic parents. So all of these faiths have as one of their tenets that sexuality is first and foremost, a religious matter. It's a question of how were you made in the image of God, and it is an area that really is supposed to be entrusted to God and practiced and lived in accordance with religious faith. And then a number of these parents also, their faith also teaches that preserving the innocence of children is important, and that the these topics of sexuality need to be introduced at the right time in the child's developmental journey. So not every it's not always the right time to have a sex education course introduced to your child. That's a tenet of faith because if that isn't honored, first of all, there's kind of a violation of the child's innocence, but second of all, um, it can be done so badly that it can harm the child's ability to live their understanding of their faith's calling. So Montgomery County began at the kindergarten level, assigning in the classroom sexuality forward reading. So these were books where the entire plot centered around the character's sexuality and generally uh, glorified some forms of sexuality that, first of all, science has not supported, and second of all, are in flagrant disregard for many religious traditions. And so the school, in apparent violation of Maryland law, uh, did not notify. Well, they originally said they would notify parents if these books were gonna be read and that they would give an opt-out provision. The school board ended up walking back both of those promises, walking back the promise to give notice and walking back the ability to opt out. And even the school administration and principals objected to this. You know, they said this is clearly not in the best interest of the child, both based on our empirical observations of how it's happening and in our knowledge as teachers. Um, but for whatever reason, the school board just marched forward. I actually looked up the school board. I was like, "Who are these people?" They seem nice, but there's some kind of disconnect here. So the parents asked for a preliminary injunction, and what that means is that the parents asked the court to press pause, um, make the school press pause on this conduct while the litigation moves forward. And so, for a preliminary injunction to be granted, the parents have to show four things, and I'll put them in reverse order. The first is that it would be in the public interest to press pause, to grant this preliminary injunction, that the balance of equities is in favor of the parents. That basically means just it gives the court a little bit of discretion, but it's kind of like the common sense. Does this make sense? Does this look right? Um, would there be irreparable harm if this pause button was not pressed? And then finally, are the parents in this case likely to succeed on the merits of the case? So that basically means, are they probably going to win? Do they have what appears to be the stronger legal arguments, assuming everything plays out, based on the facts and the legal arguments the court's presented with? So that kind of gives the bridge into what are the parents' actual arguments here. Well, they make there are four buckets of arguments. The first is free exercise, and so they cite to this beautiful, really well-known case. I feel proud of the country every time I read it. It's Wisconsin versus Yoder, and it's a case that talks about the free exercise clause, um, incorporating and protecting and just being integrated with the right of parents to bring their children up according to their faith. It makes so much sense. It almost feels like we shouldn't have to say it, but we said it beautifully in Wisconsin versus Yoder. They also make free speech claims. And when I first saw that, I was like, well, I don't where's the free speech? I was kind of curious. So the argument is that this is viewpoint discrimination, because these issues of human sexuality are there's more than one point of view on this. People of good faith have different points of view, and certainly religions have millennia of theology backing their perspectives. And the case cited there is called the Good News Club. But basically, the classroom is presenting this one viewpoint discrimination that the school board thinks is el numero uno, and nobody else is getting a seat at the table. So they're not reading books about, Maria Goretti. They're not reading books about priests or the vows of chastity or whatever. They're just reading this one perspective that glorifies a certain approach to sexuality that is objectively offensive to many faiths, and certainly counterproductive to the formation of children. And then finally, thirdly, there's 14th Amendment due process claims. So this is where a lot of the parental rights litigation has been housed historically under substantive due process in the 14th Amendment. Um, Substantive due process basically is the Supreme Court's decision. We're not going to get into good or bad, but the Supreme Court's decision that there are rights hidden in the Constitution, in the penumbras and emanations, that are fundamental. And one of the rights, this is the good application of substantive due process, is parental rights. And so there's this famous case, Pierce versus the Society of the Sisters of Jesus, and Meyer versus Nebraska, which related to parents' rights to teach their children German at a time when that was not a popular language. And then finally, Maryland state law claims. So Maryland state law 13A.04.18.01 D2E4 requires parents to have the opportunity to review the curriculum that their children are learning, and D2E2 requires that they be allowed an opportunity to opt out. And then the parents also file due process arguments or make due process arguments under the Maryland Constitution. So for the preliminary injunction to succeed, those arguments would have had to look successful. I thought that they did, but the District Court of Maryland did not. And basically, the District Court of Maryland focused a lot on the scrutiny questions we discussed last week, and said, a lower level of scrutiny is at play here. And then the Fourth Circuit agreed with the District Court, basically saying, um, that there was not a strong enough argument to support the preliminary injunction. Um, I have no idea where what I cannot understand why. But the Supreme Court has granted cert in this case, and so just about as we approach the 2-year anniversary of the litigation, the Supreme Court will bring some clarity to these issues, which I think is really, really important because it pretty much covers many of the core themes that we've been discussing on this podcast, and that we've been seeing over the past 5 years of parental rights, issues of human sexuality, issues of free exercise, and the ability of people of faith to participate in the public square without compromise. And I think this is the first time really we've discussed the viewpoint discrimination thing on our podcast, but I think that's a really important argument and a really important um, facet to the conversation around um, viewpoint, like these secular kind of views on sexuality kind of being given the state's imprimatur to the detriment of what long held, sincerely held religious beliefs. So Frank, I know you studied the parental rights issue as well, and this has been an exciting week for education and religious freedom. So what are your thoughts on this case, and what do you think we can expect from the courts?
There are so many different directions I could take this, but seeing as I have maybe 2 or 3 minutes to wrap up, I'm going to focus myself. One day we will find the right case on this podcast to discuss what we really think of substantive due process, but today is not that day. One thing I'll say is this is a really challenging thing, right? Because both morally and constitutionally, this is a fundamental question, right? Who has the right and the duty to educate children? Right, Catholic teaching is fairly clear that the parents are the primary educators of their children, and insofar as parents enlist the help of schools or tutors or whatever, they help, right, supplemental educational persons and resources and institutions. And that it troubles me to see cases like this from the outset, because that's clearly not the vision of what a school is that does things like this, that imposes a curriculum and says, the parents are not going to have the choice to opt out. Or we've seen other cases with like transgender issues, right? Use of pronouns, where school districts are encouraging or mandating that teachers hide those kind of decisions from parents and keep them secret with the child. This is just a fundamentally different view of who has the primary duty to educate and make important decisions about children. That being said, constitutionally, these are very tricky to figure out how to litigate. And so, in kind of nerdy constitutional circles, you'll hear talk about how do we get a declaration of like a fundamental unenumerated right to that parents have a right to like basic decision making over their children. It's hard because I think it's the founders never really thought it was necessary to enumerate parents have the right to make these kinds of decisions. Um, Partially, you could argue there were no mandatory public schools at the time we had the Constitution, so the thought that there would be these schools that would force decisions on parents, and this system didn't even exist, right? So it's a different world. It's very tricky to figure out how to best get these results right, and so I think it makes sense. I took a quick look at the cert petition, and I think it's pretty heavily, maybe solely focused on the question of religious exercise in the Mahmoud case. So God bless the litigators who are doing amazing work to figure out the ways to successfully navigate these in the courts. And then, final thought, this is just kind of a cultural point that you touched on, Mary Margaret, is that um, while this is about religious beliefs, right? That people have religious beliefs that are very strong about what their children should be taught, especially on like sexuality issues in the classroom, especially with young children. But I think it's important to note here that this isn't really about a particular viewpoint on sexuality. I mean, it partially is, but at least for me and from I think the Catholic perspective, this is not primarily about like our children shouldn't be learning, secular ideology about transgender issues, sexuality, homosexuality, whatever. This is about maintaining the innocence of children. Like I don't think, and most Catholics, I think, and Christians don't really think that their children should be learning much of anything about sexuality when they're in elementary school, right? This is mostly about what's age appropriate at all, not just the various viewpoints. Like I don't, I have, as you know, I have young children. My oldest is about to turn 7, and I would have no interest in any school or any person teaching them about anything related to sexuality at all, because they don't need that, because they're young children and their development doesn't require it. Their innocence requires that they kind of be left alone on these issues. So I think it's just worth pointing that out. This isn't about, religious saying we don't want homosexuality and LGBT issues. We want, religious versions of sexuality. It's like, no, I think most of these parents just don't want any sexuality being taught to their children at all. Um, anything you want to finish up or clean up with on that, Mary Margaret?
Yes, I just couldn't agree with you more. It seems like such a clear-cut issue, and on one hand, I'm frankly surprised it got this far, but on the other hand, I'm very pleased, like, that the Supreme Court will be providing clarity on this and specifically addressing again the parental rights issue, which, we refer so often to the Pierce versus Society of the Sisters of Jesus cases. These are cases from, I believe that one was 1925, if I recall correctly. So, and I believe Yoder was maybe the 60s,
I think it was the 50s, but yeah, that era.
50s, yeah. So it would be good to have an opinion from the Supreme Court that connects the dots with kind of where we are today with religious freedom questions, and then linking that to parental rights questions because those are in conflict whether we have clarity or not.
Just fact checked us here. You were closer, but it was 1972. Wisconsin v. Yoder was decided. Um, yeah, there's so much more that could be said on this topic, and I'm sure we'll be touching this case in particular as it moves into the Supreme Court and these kinds of issues in future weeks. But I think we should probably wrap up there.
Great. Well, thank you for joining us on this episode of the Napa Legal Podcast. If you enjoy the content we are putting out, we would appreciate if you would like this podcast and subscribe to our channel on YouTube, Spotify, or whatever platform you use to listen. We hope you will join us next week as we continue to highlight and discuss some of the most important ongoing legal issues affecting religious liberty and the work of faith based nonprofit organizations.
We'll talk to you next week. Thank you for joining us, and God bless you all.